Welcome to this week's installment of Rochelle's Daily Wire Video Edition. This week we're going to do something different. Rather than forcing you to listen to me for a few minutes, instead we're going to interview one of the leading figures in the bankruptcy community. So sit back, relax, and let's learn something about bankruptcy law. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. And for the next few minutes, I'm going to be talking with Robert Drain, bankruptcy judge in New York, now White Plains, New York. Judge since 2002?
Yeah.
Is that right?
Yeah.
Well, and before that, he gave up a cushy position as a partner at Paul Weiss Rifkin to become a penurious bankruptcy judge. So talk about financial sacrifice, you're looking at it. Judge Drain is somebody I've known forever and have always, when I was practicing law, liked to be in his court. And frankly, evidently, a lot of people like to be in your court, because I always tell the story that it seemed to me that you left Lower Manhattan to go up to White Plains hoping you would no longer have to deal with big cases. But what happens? They file up in White Plains because they know they're going to get you. And that's a great compliment to how the bar views your capacities as a judge. But what I would like to talk with you about, Judge Drain, is been one of the most interesting topics in the last couple of years. Because about 2 years ago now, a district judge in Delaware turned the bankruptcy world on its ear when he suggested, he didn't hold, but he suggested and asked Judge Silverstein to consider whether a bankruptcy court has constitutional power in view of Stern versus Marshall to enter a final confirmation order that gives third-party releases. Because if you didn't have the ability to enter a final confirmation order, Lord of mercy, these bankruptcy cases that need quick conclusion wouldn't have quick conclusion.
Or you'd get rid of third-party releases and injunctions, which are important to a lot of these cases.
Exactly. So tell me, Judge, how has this developed since then?
Well, this past year, including fairly recently, both in that case, the Millennium case, and in the case of mine that went up to the Chief District Judge in the Southern District of New York, the district court affirmed the bankruptcy judges, both of whom found that we actually did have the power under Stern in the context of confirmation to approve a third-party release and injunction.
Well, listen, let me play the devil's advocate for a minute and make the counter-argument. When you're giving immunity from state law claims to third parties, that seems very much like a final judgment on a state law claim. So how can there be constitutional power to enter that equivalent of a final judgment?
Well, remember that in Stern, and going back to Marathon and Marathon, the focus is on what is core to the bankruptcy power. What's not core in terms of 28 U.S.C. 157, but what's really central to the bankruptcy power. Because the Supreme Court, even though it has grappled with the Article I status of bankruptcy judges, recognizes, I think, that it's in Article 1 of the Constitution. Congress shall have the power to make uniform bankruptcy law, and judges did it then. Ultimately, they supervised it, and judges do it now. So there's something central to bankruptcy that we do have the power to issue final orders on. In both of these opinions, and Judge Silverstein's opinion was really remarkable. It was very scholarly, very well thought out.
68 pages long.
It was a long opinion, and the district court affirmed it, quite with a great deal of praise. Both the district court in Delaware and the district court in New York said, look, there's nothing more central to a Chapter 11 case than confirmation. That's the whole goal of a Chapter 11 case, is to do a plan. And if the release is consistent with the plan, consistent with the notion of a collective proceeding to resolve the claims against and assets of the debtor, then it's it's that basic core bankruptcy proceeding.
I see. So it's
Judge McMahon said, look, there are obviously limitations to this. You can't shoehorn into a bankruptcy plan releases that go to things that are completely outside of running the bankruptcy case or the things that caused the bankruptcy case in the first place. But generally, the types of releases we see aren't like that. You know, they're releasing claims that are related to the bankruptcy, to the conduct of the bankruptcy case. And when you look at 1141, and again, Congress has the power to enact a uniform bankruptcy law. 1141 is not just a discharge provision. It's a provision that says the plan is binding. And courts have read that language, as well as common law res judicata, to say that bankruptcy plans are, in essence, super contracts. But they're signed only by the plan proponent, but they're on due process notice to everyone. They have their chance to object. The objections are heard in the context of plan confirmation, and it's core.
yeah. You know, I remember at the time the original district court opinion came down raising this specter. I was thinking to myself, you know, what would the implications be if indeed you could not give a final order with a third-party release? And then it dawned on me, well, among other things, what about the allowance of a claim? Because you're inevitably making a final judgment on an allowance of a claim under state law. And of course, I guess actually come to think of it, the Supreme Court has never opined on where that power rests.
Well, they have vacillated. One of the best programs I've ever seen was at this conference, a new book by Professor Mann at Columbia on the Supreme Court since '78. And he talks about, in the constitutional cases, the tension between narrowing bankruptcy power and expanding bankruptcy power. And the Supreme Court has never really latched on to a rationale for either one. They recognize that it's necessary, it's in the Constitution, and there's a certain ambit where it works and is appropriate, but they've always been a little reluctant to define that ambit. And you know, these issues could go up to the Supreme Court. I mean, I don't know what the status of Millennium is. The litigant in my case, where Judge McMahon affirmed me, is very litigious. I don't know. You know, it's the type of thing they might take cert on. I don't know. I hope they don't, frankly,
Well,
because I think, generally speaking, judges know where plan proponents abuse this right and curtail it, and otherwise, you know, particularly with a plan that's satisfies due process, that's widely accepted, they'll let it happen because it avoids strike suits and it settles the case. It helps settle the whole case.
Well, thankfully at this point there is not a circuit split. And I've always had the sense that the Supreme Court, if they possibly can, will not tackle a Chapter 11 issue because they're afraid of upsetting the apple cart.
Well,
I think they realize their limitations, especially in knowing what they don't know.
maybe. You know, it's interesting though, some of the cases they do take, they may think don't affect Chapter 11, you know, because they just affect a truck or you know, a car, but obviously they do.
Well, this is very good stuff. Judge Drain, you've got to go off and do a panel of your own right now.
I do, yeah.
We thank you for taking time to talk with us.
Thanks for having me.
I hope we can come back again sometime at another ABI event and explore these and other constitutional issues with you. Meanwhile, let's give our thanks to Judge Drain. Listen, be well, don't work too hard, and we'll see you again at one of these programs soon.
All right, thanks, Bill.